Hello and welcome back. This next installment of our PowerPoint and narratives is going to focus on business organizations. And this is on chapter 14 in your textbook. So we're going to be discussing business organizations in the legal and regulatory environment of business. And certainly this is one of the most important aspects or chapters in my view of our course study. A lot of material in chapter 14. Please take your time and go through this material carefully. Use the tools that our authors and editors of this 17th edition have provided. Take a look at this in detail, and I'm going to highlight some of the main aspects here of this chapter for our discussion today. Let's talk about the form of business organizations. The form of business organization must be considered at some point for anyone interested in owning and conducting a business. Without considering the form of the business organization, one's really at a disadvantage, because at some point the form will be an issue because it lends itself to so many different legal considerations, and we'll talk about that in just a few minutes. But there are three basic forms of business organizations that should be considered in operating a business. One would be a sole proprietorship, one is a partnership, and one is a corporation. These are three of the primary forms of business organizations, and we'll talk about these forms and others in much more detail in just a few minutes. There are hybrid forms of organizations which include limited partnerships, S corporations, limited liability companies, and limited liability partnerships. And again, we'll talk about these hybrids, if you will, in just a few minutes as well. Let's talk about a concept, or a term rather, and that is a closely held corporation. You may have heard that term used in other settings. A closely held corporation is one owned only by a few people. Other businesses may be owned by hundreds, if not thousands of persons. Those organizations are publicly held. I'll define that term later on as well. But a closely held company or corporation is traditionally one that is just containing a few people. Most of the time there will be individuals who know each other very well. They may be family-owned enterprises. They may be enterprises formed amongst friends and colleagues and others. Companies whose stock is traded on public exchanges such as the NASDAQ or the New York Stock Exchange would not typically be closely held corporations. There are factors to consider when considering the form of a business. Kind of a redundancy there, sorry about that. But some of the factors would be continuity of the business. What happens when there is a dissolution? And that's a term that you should understand by definition and also application. Decision making. How is the business going to be managed? How is the business going to be operated? Who's in charge? Who's responsible for what and when? And of course, personal liability is a huge factor when considering the structure of a business. Individual liability may be something that can be shielded when it comes to a corporate format, and we'll talk about that in just a few minutes as well. And then taxation. Taxes make a huge difference with respect to the application of these different forms of businesses, how the businesses are going to be taxed and to what extent. So those are all considerations when deciding the particular type or form of business operation that is going to be involved and what the legal structure of same can be. Let's talk about continuity. Continuity is a factor to consider. A change in the ownership of an organization may change the actual legal existence of that business association or that organization. A dissolution may occur when that change takes place. For example, if you have a partnership between two or more individuals, when one of those individuals who carry on that business together, who have carried on that business, when one dies, that is a dissolution effect. So too may be the retirement of one of the partners, or the withdrawal of an owner can also create issues of whether an organization and its business will continue, not just if it's in a partnership format, but in other aspects as well. So continuity of the business, whether it survives, whether it continues, and in what shape or format, should be factors to consider as well, should be a factor to consider in deciding what structure and legal format the business should be set within. Personal liability is another factor to be considered when organizing a business. You may have already encountered that section in your reading involving personal liability, but the degree the owner is personally liable for the debts of the business will impact on that owner's personal status. In other words, a business owner may be responsible based upon the form of the business for the debts of that business on a personal basis. That may be one of the reasons to incorporate and to operate a business in a corporate structure as opposed to the structure of a sole proprietorship. Individual liability is when individuals, their own stake, their own worth, their own assets can be subject to attachment, through the court process, and can be exposed to claims of liability, claims to satisfy damages when liability has been established. And we know what the term liability means. That's legal fault, that's legal responsibility, and individual ownership can certainly be shielded in some respects based on the type of business structure that is put into place. Let's talk about a sole proprietorship. A sole proprietorship means it's owned by an individual person. Sole proprietorships can be large businesses that may have many employees. In fact, students that I've taught over the years have expressed the perception that a sole proprietorship is really just one person owning a business and operating the business. That may be true, but a sole proprietorship may also be an individual who has many, many employees and a very developed business structure. A sole proprietorship, the continuity exists as long as the proprietor desires or continues to have an interest in that business. No formal documentation is required. Usually only a business license will satisfy the requirements of operating a business solely or individually in that respect. The aspect of control, that's a huge factor as well. The aspect of control, well, who of course is responsible for the control of a business operated by an individual, owned by an individual? That's going to be that person, that proprietor. Personal obligations for all debts and liabilities will be the responsibility of that proprietor, that owner. And of course, taxation, when business income is obtained, guess who has to be responsible? The owner of that business, the individual sole proprietor. So a sole proprietor is an individually owned business. And just again, not to be redundant, it's a form of the business organization. And people can choose to operate a business in a sole proprietorship status for lots of reasons, a variety of reasons. Simply because the form of business is based on a sole proprietorship status doesn't mean that other organizations are better or superior to that. It just means that a decision was made for whatever reason to continue the operation or even structure the operation, and the status of that is that of a sole proprietor. Let's talk about partnerships. Partnerships can really become automatic based on the type of business conducted. If two individuals, and I'll just use these same two individuals that we've talked about by example throughout the course, if Ann and Bob decide to operate a business, well, because there's two people who operate and own a business, Ann and Bob, it means by definition that they're not in a sole proprietorship setting, they're in a partnership setting. So by their conduct, by their operation together in owning and operating that business, they are partners and they formed a partnership. Now, you're going to read in your textbook, and I'm certainly going to tell you as a lawyer, that partners who operate in a business should have a very well-defined partnership agreement that will specify, for example, who does what, who's going to be responsible for what area of the business, and even profits and losses, how they're going to be shared. In the absence of a partnership agreement, the law infers that profits and losses are going to be shared equally between the partners. Profits and losses will be shared equally in the absence of an agreement that states otherwise between the partners. And a partnership doesn't necessarily mean that it's just two individuals. You may have multiple individuals who form a business relationship and carry on that business endeavor in the form of a partnership. Now, how long does the partnership exist? The continuity continues until there is a dissolution. A dissolution occurs whenever one partner withdraws or no longer is involved in that partnership endeavor. Each partner, in terms of control, has an equal right to the direction and status of the organization. And of course, that can be modified by having a detailed partnership agreement that will specify, again, the areas of control, the subject matter of management. Let's talk about liability in a partnership setting. Personal obligations are going to be available to satisfy all debts and liability. Joint and several liability is a concept that is certainly applicable to partnerships. So let's say, for example, that Ann and Bob have a business and that they're operating in the form of a partnership, and they have no formal partnership agreement whatsoever. Let's assume that their business is sued by a third party and is successful. Let's assume further, in my example here, that Ann has contributed $10,000 to the operation of the business, and Bob has contributed $50,000 for the operation of the business. So they've got $60,000 involved in equity for that business. And I do see here, as I'm looking on the screen, that I've mistyped partnership. We're missing an I after the H and before the P. So sorry about that. So continuing on in my example, if a judgment against Ann and Bob's business is obtained by a third party for $100,000, Ann invested 10, Bob invested 50, that's what they've got in terms of equity in the business. How much are each of them going to be responsible for toward the $100,000 judgment? Well, the answer is they are jointly and severally liable, meaning that even if Ann invested only $10,000 and Bob invested $50,000, each of them separately have individual exposure to satisfy that $100,000 judgment. So if Bob happens to be a multi-millionaire outside of operating that business, the judgment creditor could seek out only Bob's assets in which to satisfy the judgment. On the other hand, let's assume that Bob is really doesn't have any assets to satisfy the judgment, but Ann does. But her assets are going to be limited to $75,000. Well, if she has $75,000 that can be attached, that's going to be certainly obtainable by the judgment creditor, regardless of her $10,000 contribution. So the concept of joint and several liability in a partnership is something that should be considered with respect to the management and startup of that company and the legal operation of it, and the structure, of course. And all business income is going to be subject to personal taxation, and it's again going to be divided equally. All income in the absence of an agreement will be divided equally amongst the partners. Lots of information on partnership status. Make sure that you have a good understanding about that from your chapter reading. Let's talk about the corporation. The corporation. How does a corporation exist? Well, you have to seek the creation of a corporation through the state. The corporation is a creature, if you will, of the state. It's created by the state. And as long as the state exists, its continuity is going to be perpetual. Incorporators apply for a state charter with the Articles of Incorporation. Once those Articles of Incorporation have been submitted to, let's say, for example, in Illinois, it's the Secretary of State. Once the articles have been submitted, approved, and all of the fees as a requirement are paid, then the state will issue the status of incorporation to that business. The control of a corporation is going to be through its officers and appointment by directors, and also those who are elected by shareholders. So it's managed by officers, appointed directors, and shareholders at their direction. The shareholder obligations in terms of liability are going to be limited to the investment, absent some other commitment or contract. But let's assume, for instance, that Ann and Bob have decided to incorporate their business. And let's assume further that based on the last example I used, that Ann contributes $10,000 and Bob contributes $50,000 to that business. If that's going to be their shareholder obligations, and they're in a close corporation, then their extent of liability will be limited to their investment, absent some other commitment or some other controlling contract or agreement. So with a corporation, their individual assets will not be exposed to damages should liability against the corporation be established by some third party. Let's think that through. A third party creditor, for example, can only seek and attach the assets of the corporation. And each shareholder's contribution to that corporation, evidenced by shares, will be the extent of their liability. So Bob could be a multimillionaire, as could be Ann, but their personal assets will be shielded from liability in terms of the responsibility of the corporation to some third party. I hope that makes sense. Please read that section closely in your textbook. The reason primarily for incorporating a business, and this is all legal, this is all proper, this is all ethical, is to shield liability from the individual owners who are shareholders, and to place that liability on the corporation itself. So the individual shareholders, the extent of their liability will be the limitation of their investment. Let's talk about taxation. Taxation is certainly another nuance of the corporation status. Corporate income is taxed. So if the corporation generates income, it can be taxed based on whatever income that is subject to, taxation. Shareholders are taxed only on the income which is distributed from the corporation. Now let's think this through. If I've said that the corporation will be taxed on the income it generates, that's one tax, right? And if the shareholders are taxed on the income which is distributed from the corporation, then that's another tax. So with respect to taxation, there can be literally a double taxation, both to the corporation and also to the shareholders who receive a dividend, for example, from the company that is subject to tax. One of the things I mentioned a while back in an earlier discussion was that the corporation is considered in the eyes of the law as a person, So the corporation has ongoing, continued operational status as long as it's operated within the format of the law, of course, and is recognized by the state. Its existence will be perpetual, and it's also subject to taxes. But unlike a human being who's a person, obviously, death is going to end that person, but the corporation, on the other hand, since it's a creature of the state, so to speak, its life can be ongoing and perpetual insofar as long as that state is in existence and corporate formalities are adhered. Let's talk about a limited partnership. Well, we know what a partnership is, but a limited partnership is another form, a hybrid, if you will, of a partnership. The partnership agreement and certificate is usually going to be filed with the Secretary of State's office or in another public office where the business is conducted. It can be dissolved when a general partner withdraws. General partners have total control of the operation of the partnership. A general partner is one that will be, in many instances, responsible for the liabilities of the partnership and won't be able to shield liability in the same way that a shareholder would operating in the form of a corporation. Personal obligations for general partners will be available, and outside creditors could certainly sue the limited partnership, and the general partner can be responsible. The limited partners, however, in terms of liability, will be responsible only for their share of the investment. So similar in some sense to a shareholder in a corporation, but different, of course, because it's a different format. The limited partnership is usually an endeavor that is going to be focused on some specific time frame in which the business will be conducted, or until the purpose or the object for that business operated in a limited partnership has been completed. let me give you an example. Let's say that a general partner, and let's say the general partner is Clyde, and Clyde wants to start a shopping center or a strip mall, if you will, but knows that Clyde doesn't have the financial wherewithal to start that operation on his own. He needs capital contributions from others to get the business developed, to have the business ongoing, obviously to even have the buildings constructed and managed. So Clyde decides that he will attract and seek out limited partners to engage in this operation. And so he's offered, for example, Dana or Erica investment opportunities, and their investment will be, if it's conducted in a limited partnership, their exposure to liability. So let me give you an example. Let's say that this whole shopping center, this strip mall, has been developed and it's ready for sale, and the sale of that partnership will generate income. Will generate income and hopefully will certainly provide income beyond the investment of the general partner and the limited partnerships shares in that operation or in that startup. But before the business is sold, let's assume that there's been some claim for liability. And if the claim for liability is sustained or is entered by a judge or jury in a lawsuit, then who's going to be responsible generally for that claim of liability? It will be the general partner. Dana and Erica, on the other hand, their exposure to liability will be whatever their limited investment was in that limited partnership. So if the whole arrangement, the whole operation is going to be sold to satisfy the debts and the liabilities, then the general partner will assume the lion's share, if you will, of that liability and the damages, but the limited partnership, after everything is all sorted out, the limited partners will only be exposed to their limited investment in that endeavor. So, long description. I hope it makes some sense, and I hope it sheds some light here on your understanding of this concept. An S corporation. Let's talk about a subchapter S corporation. It too is perpetual. It's perpetual, but with a subchapter S corporation, it's traditionally going to be a smaller size company. It'll be a close corporation. You're not going to have a large number of shareholders who are going to qualify as shareholders under a subchapter S. All business income is subject to personal taxation. So one of the aspects of a subchapter S corporation is that it still provides the liability shield from others outside of the company, third-party creditors. The shareholders will be shielded in the same sense of an ordinary corporation provides, but the difference in terms of taxation would be that individuals are going to be responsible for the business income that will result in taxation. In other words, all business income is going to be subject to the taxation of the individual shareholders or the owners of this subchapter S corporation. Now, what does a subchapter S corporation provide? It again, the same benefits as a corporation, but it avoids the double taxation aspect. So instead of two taxes, one imposed for the income generated by the corporation, and two, the tax to the individual, all of the income flows to the individual subchapter S shareholder. So you avoid that double taxation aspect. It's again going to be managed by officers who are appointed by directors, who in turn are elected by the shareholders. And the shareholder obligations will be, of course, limited to their investment, absent some other commitment or agreement to the contrary. Now, we also have hybrids called limited liability companies or limited liability partnerships. And that's going to be based on the law in the various jurisdiction, but it's dissolved when a member withdraws, but may be continued by those remaining if they've got an agreement in place to that effect. Members are agents and are liable only for their investments. So you're not going to have, for example, a general partner, much like a limited liability partnership. Instead, you're going to have members. So shareholders will be called members, and they're liable only in terms of liability and damages claimed for any harm that the limited liability company does or the limited liability partnership creates, only to the extent of their investment. And with respect to taxes, all business income is subject to personal taxation. So it's much similar to the subchapter S. But with a limited liability company or a limited liability partnership, the organization may be structured for a short-term duration or for a specific purpose until that purpose has been satisfied or once that objective has been complete. It does have the potentiality of being ongoing, but it's dissolved when a member withdraws, but it could certainly be continued by agreement otherwise. And you'd have limited liability company agreements, you'd have limited liability partnership agreements, and all that can be detailed and structured out by way of a contract. So I hope that gives you an overview, a very general overview of these different forms of business ownership and structure, and also some of the advantages for each. So when it comes to the advantages, look at continuity, control or management. The liability, of course, is a huge factor to consider, and taxation. And again, all of this can be examined in much more detail in your readings in this particular chapter. Let's talk about corporate formality. When corporate formality is disregarded, when I talk about corporate formality, that is having the corporation structured in a way that the laws require. You have regular corporate meetings, you have regular shareholder meetings, you have the company organized by way of directors, officers, shareholders. When the formality of the company is disregarded, then a so-called piercing of the corporate veil, you may have heard that term, could be available. Corporate organizations are required to maintain corporate formalities in every respect, corporate formalities based on what the law imposes. Misuse of the corporate organization and disregard of its status. For example, commingling personal and corporate funds, payment of personal expenses from corporate funds. That's a disregard of the formality of the corporateness that the law requires. When that disregard occurs and liability is created, some third party has been harmed, and when they seek to enforce a judgment or make claims of liabilities based on what the company has done and created damages to others, then the individual shareholders who manage the company, if you will, especially in close corporation settings, they may be subject to the piercing of the so-called corporate veil and then be exposed to individual liability. Remember, one of the main reasons to create a corporation is to shield individual liability. Once that's created, it doesn't mean that individual liability will always be shielded. Corporate formalities will be required, and when they're disregarded, then third-party creditors can attack the corporateness of the organization by piercing the so-called corporate veil that will then expose individual shareholders to liability claims to satisfy damages. Let's talk about the alter ego theory. You may have heard that term. It's also contained in your textbook. The alter ego theory, by which the corporate veil can be pierced, may also be used to impose personal liability upon the corporate officers, directors, and shareholders. If the corporate entity is disregarded by these officials, such that there is a so-called unity of ownership and interest, that separateness of the corporation in effect ceases. When there's a commingling of funds, when the organization is really an alter ego of the individual, then the alter ego theory will be applied and the corporate veil will be pierced. And again, there's more detail in your textbook, but the purpose of this presentation, as well as all the others, is to highlight some of the main areas that we should be focusing upon in your textbook readings. I also wanted to touch on excuse me, the term public corporation, because there may be some misunderstanding about that term. A public corporation is a corporation formed by the government, not individuals, but by the government to meet some political or governmental purpose. As an example, cities or towns are incorporated. And so it's a public corporation. Amtrak or the U.S. Postal Service are examples of public corporation. Note that a public corporation is not, however, the same thing as a publicly held corporation. And let's talk about a non-for-profit corporation. A regular corporation, its main objective is to make money, create a profit. Corporations can also be formed for the purpose of not making a profit, and those are called a non-for-profit or not-for-profit corporation. It should be, again, I've got a misspelling or a typo there. It's not-for-profit or non-for-profit corporation. And that would be a corporation that has been designed to achieve not necessarily the making of money, but the promotion of some type of policy or purpose for social endeavors, as an example, or for educational endeavors, as an example, where they can still make money, but that the focus of their existence is not for profit. It's for some other objective or purpose beyond that of solely making money for the shareholders. So hopefully that will give you some of a big overview highlight of the subject areas in this chapter that you should be familiar with and have some understanding about. Again, thanks for your time. Thanks for your interest. I hope this has been helpful. Thank you.